Can family members still join the application after the main applicant already gets the residence card, or do they need to join the main applicant in the beginning? Hello everyone, I'm Winter and welcome back to American Asia Processing Corner. In the previous episode, we talked about who can legally be included as a dependent under the Panama Qualified Investor Program. In this video, let's go through another very common practical questions. Do dependents need to be included from the very beginning, or can family members still be added later after the main applicant already obtains residency? We'll also briefly explain the legal framework behind these procedures under the Panama immigration regulations, including the Decree Law No. 3 of 2008 and Executive Decree No. 320 of 2008. Now, let's get into it. So, what's the answer? The good news is not necessarily. So investors may choose to include the dependents at the start of the application or add them later. However, there are some key differences you should understand in each situation. First, including dependents from the very beginning. And in most cases, this is actually the recommended approach. If the spouse, children, or parents are already expected to be part of the application, including them at the start is usually the simplest and most efficient option. Why? Because the residence application for the whole family will be processed together with the main investors. That means the investor generally won't need to go through a separate family reunification process later on. Let's say another option once the main investor has already obtained permanent residence in Panama and later decides to bring a spouse, child, or parent. Can this still be done? Well, yes, but the process is different. So instead of being included in the original investment application, the dependents would need to go through a separate application under the category Permanent Residence Provisional Permit. The dependents of permanent residents, following by Article 28 of Decree No. 320 of 2008. So, as previous detailed, you may know eligible dependents include parents, spouse, children under 18, and children between 18 and 25 years old, provided that they are full-time students, single, and financially dependent on the made permanent resident. The dependent will be granted a 2 years provisional residence permit, and after completing the legally required period, they may apply for permanent residence. In practice, if the principal investor has already been approved under the qualified investor category and later wishes to include dependents, they are generally required to demonstrate the financial capacity to support dependents through the regular dependents reunification route, such as through bank statements, proof of financial support capacity, or other supporting financial documents required under the immigration process or lawyer's checklist. The minimum balance requirement may vary from time to time depending on the applicable regulations issued by the Panamanian authorities at the time of the application. Now, in terms of documentation, this is where compliance becomes critical. Here are required documentation for the dependents application: passport copies, background verification documents such as criminal record, duly legalized or apostille as required, health-related certification issued in Panama, documents proving family relationship with the main applicant such as birth certificate or marriage certificate, supporting documents evidencing dependency where applicable such as proof of schooling, proof of singleness, proof of economic solvency of the permanent resident such as Panama bank account with a minimum balance in accordance with the government requirement, letter of responsibility from the permanent resident. Kindly remember that administrative costs may apply. And also please note that the residency period begins on the date the dependent's own permanent residence is approved, not from the date the main investor's residency approval. And of course, required documentation may vary depending on the client's background and the nature of the assessment by the Panamanian authorities at the time of the application. In today's episode, we've gone through the key practical and legal aspects of adding family members under the Panama Qualified Investor Program, including whether dependents must be included from the beginning, the available options for adding dependents after approval, the eligibility conditions applicable to each dependent category, and the compliance and documentation considerations that may arise during the reunification process. I hope this video has helped clarify some of the most common questions regarding the family inclusion and dependent applications under the Panama Qualified Investor Program. As always, every family structure and immigration situation is different, so if you would like a more detailed assessment of your case, or if you still have the questions regarding the program, please feel free to contact American Asia for further support and guidance. This video is also part of our ongoing training series for American Asia's international partners around the world. We also welcome new strategic partners interested in collaborating with American and learning more about our investment and real estate opportunities in Panama and other international markets. And of course, don't forget to follow American Asia so you can stay updated with our upcoming episodes and impression insights. Thank you for watching, and we'll see you in the next video.